Hi, this is attorney Michael P. Kimbrell. I'm based out of Las Vegas, Nevada. Used to be a vocational expert working for the Social Security Administration back in the 90s when I was going to law school. And this gave me a very special understanding of the Social Security disability process in terms of who's more likely to be found disabled given their work history and their education and their age and the physical and mental demands of the kind of work they performed. I tell you that as just an introductory remark about my background that's kind of sets me apart from most SSDI, Social Security attorneys. I haven't yet met one that has been a vocational expert. I earned a master's degree in counseling back in the 80s, back in St. Cloud, Minnesota. But what I wanted to talk about today, just briefly, are the 5 sequential steps that Social Security uses in evaluating a claim. If you have ever been to a Social Security hearing in front of an administrative law judge, the judge often will ask the attorney, have you explained the 5 evaluation steps to your client? Do you waive a reading of those steps? But for those of you who have not really heard it explained what the steps are, they're fairly straightforward until we get to 4 and 5. Step 1 is simply, are you working? And if you are working, are you earning enough pre-tax money to basically get you an automatic no at the application point, step 1. That limit in 2014 is approximately $1,040 before taxes. So even if you earned that amount of money in 1 minute of each month, and then you were in bed on a lung machine the rest of the month, you would still be found to be not disabled because that amount of money per month pre-taxes is considered substantial gainful activity. But most people don't run into rejection on the earnings step, number 1. Number 2 sounds very demanding, but it says, do you have a severe medical or mental condition that prevents you from working? But the truth is, it's a de minimis test. I often explain to clients that you probably, if you had a simple report of your back evaluation from a chiropractor, let alone full-blown hospital surgery records for shoulder surgery or back surgery, either one of those, if it's from a treating medical provider like a chiropractor, surgeon, general practitioner, family doctor, or specialist, that's going to get you past step 2. Step 3 is, do you meet or equal a medical listing? I basically never see clients that need my assistance because those kinds of clients have such serious medical problems and the evidence has been so specifically identified by Social Security for something such as Lou Gehrig's disease or certain types of cancers. It's so serious that once Social Security has the evidence of that kind of condition existing, they presume that person is disabled and not able to work. Most people end up duking it out at step 4 and step 5. Step 4 is where Social Security informs you if you've applied and you've been denied recently. And there's a number of different denials. The durational denial, they say your condition's not going to last over 12 months. There's the not severe enough denial where they just say you have a severe condition, but it doesn't really prevent you from working. Then the pure step 4 is, well, assuming you've listed 3 different jobs you've worked at full-time for at least 90 days over the past 15 years, say waiter, cashier, and telephone receptionist, for example. Social Security at step 4 might say, well, we agree that you cannot tolerate the physical demands of standing and lifting as a waiter or even as a cashier, but we believe that you should be able to return to your past relevant work as a receptionist, for example. And then if you appeal that through a request for reconsideration, and future videos will go more into detail about these stages, and then if you appeal that and request a reconsideration, often they'll come back and now they'll reject an application or deny the benefits at step 5. And that's where they say, although your condition, and they'll label the conditions and state them all, usually, they'll say, well, you can't return to any of your past relevant work. There are jobs that exist in significant numbers in the national economy that we think you can perform. And this is where it shocks the monkey, so to speak. I mean, these are jobs that high school juniors, no offense to juniors, could probably learn in 30 seconds or less by simple demonstration. We're talking unskilled minimum wage jobs like small parts inspector, a surveillance system monitor, an information clerk, somebody who sits in a hospital, and usually they're volunteers that do this job, but the vocational experts can cite the numbers that exist in our economy here in Las Vegas and elsewhere. And they'll say, these types of jobs you should be able to perform. They provide a sit-stand option. You don't have to lift over 10 pounds. It's pure sedentary, unskilled. And if you happen to be a person who's pursuing disability through Social Security and you're under 50 years old, my job, if you were my client, is to gain and produce the medical evidence along with your, your own testimony at a hearing, assuming we get tonight at the reconsideration stage, is to show a judge that in the totality of all the problems you have physically and mentally, that you cannot even do one of those unskilled step 5 sedentary sit-stand option jobs on a competitive basis. Many clients, they don't want to really believe that they are not able to work anymore. They like to believe it's all going to change in the future, and I understand that. But the reality is, if in the past 1, 2, or 3 years you haven't had a series of 5 days in a row where you could perform even a simple sit-down job, sitting or standing when you need to, hardly lifting anything, but functioning, concentrating, staying on task for 8 hours a day, 5 days a week, which is your typical full-time definition of full-time employment. If you can't say you have done that or really honestly could do it, you need to put up the fight, and you need somebody to help you and help Social Security understand that you can't even do simple unskilled work if you're under 50. In a future video, I will detail more about what happens if you're between the ages of 50 and 54, 55 and 59, what kinds of medical treatment should you receive, should you have an attorney or an attorney representative before you even apply. I'll detail those stages in additional YouTube postings. But I invite you to check out my website, mpkimbrallaw.com. I welcome your emails if you have queries, fact patterns, questions about where you are at your stage in the Social Security disability process, or if you're considering applying, be more than happy to shoot you back an email. I'm at info@mpkimbrallaw.com or mpkimbrell@aol.com. And my interstate number is 1-877-471-7001. I don't get that out very often. And my local number is 702-471-7001. I wish you the best.